Okay. Okay, Fauzi, let's start the presentation. Press F5, please.
Kamu cuk.
Okay. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Rafi Abdul Salam, and I'm with my friend Muhammad Fauzi. We're gonna present our material about the judicial analysis of application for underage marriage in the perspective of children protection law and Islamic law, and then actually in civil law. Okay, this is our outline of this paper. First, we're gonna talk about the background of this paper. We're gonna talk we're gonna talk about the reason why we choose this topic and why we must do this research. And then we're gonna talk about the Islamic law perspective on underage marriage and marriage dispensation. And then we're gonna talk about the children protection law perspective of underage marriage. And then we're gonna talk about the dispensation of marriage and underage marriage in the perspective of civil law. And then the last we're gonna talk about the conclusion. Next. Okay, here we are in the background of the paper. Underage marriage is a marriage carried out by someone who is still under the age that has been determined in the legislation. Child marriage in Indonesia is quite high. Although the rules regarding the age limit for marriage have been determined, however, there are still deviations from the age limit. The marriage dispensation in the marriage law doesn't provide clear requirement and procedure in applying for a dispensation. This study aims to determine the Islamic law and children protection law perspective on granting dispensation to underage marriage at a religious court. Okay, Fauzi, time is yours.
Next is Islamic perspective. In Islamic law, there is no age limit for marriage. Islam view a marriage as valid not the basis of age, but on the basis that the pillars and conditions of marriage have been fulfilled, namely the presence of guardian and two witnesses, as well as the dowry and the wedding contract itself is legal according to Islam. The view of Islamic law regarding underage marriage is that if a child has reached akil balik mumayyiz, can distinguish between right and wrong, fulfill the pillar and requirement for a valid marriage, and is able to be responsible for both the economy and other household needs, the marriage is considered valid. According to Imam Shafi'i, for a child who is not yet an adult, that is not reached the age of 15 years old, has not had menstrual bleeding, the father may marry off his child without prior permission. This is called hak ijbar, on condition that it does not harm or benefit the child or goiro nuskon laha. Okay, next.
Okay, Fauzi, thank you for the explanation. Okay, so we were in the children protection law part. The birth of the Children Protection Act is an activity to protect the dignity of children and the rights they have so that they can live, grow, and develop optimally and participate optimally in accordance with the human dignity. The purpose of this protection is so that a child can participate in the development of a nation and state. The Child Protection Act must lay down the obligation to provide child protection based on the following principle. That is, first, non-discrimination principle. Then the best interest of the child. Then right to life, survival, and development. And the last is the respect of the children's opinions. Okay. The case of underage marriage occurs because of the granting of a marriage dispensation by the religious court. Marriage dispensation creates a legal impression of underage marriage. In addition, it also seeks to simplify the marriage process. The occurrence, the occurrence of child marriage changed the status of a child in the eye of the law. A child who is married is considered an adult, even though his status is discovered, he is still considered an adult and does not return a state of minor. The obligation to provide the protection for children must also be based on the principle of child protection. Next. If all the principles of the right to life, to survival, and development are not fulfilled, this marriage dispensation is not appropriate. If all the rights mentioned are not fulfilled, if it will have an impact on the state. In other words, the country will experience a setback due to the low level of education and high maternal mortality rate caused by the child marriage. Okay, Fauzi,
Okay.
time is yours.
Okay. Next, underage marriage according to civil law. For bridging between the natural needs of human with the achievement of essence of marriage, the marriage law has established the basis and conditions that must be met in marriage. One of them is in Article 7, Paragraph 1 of Law Number 1, years 19 and 74, concerning marriage with marriage is only permitted if the male party has reached the age of 19 years, I mean, and the woman reaches the age of 16 years. It is very clearly stated in Article 26, Paragraph 1.c of Law Number 23 years 2002 concerning child protection that parents are obligated and responsible for preventing child marriage. The inclusion of the sentence is a must that must be mutual attention. This is because children are forced to marry at an age that is still classified as a child from the aspect of children right. They will be deprived of the right such as the right to play, the right to education, the right to grow and develop according to their age, and in the end compulsion become an adult. Marriage dispensation cases are civil cases that are submitted voluntarily or application. Voluntary cases have characteristics that make them different from contentious case or lawsuit. The characteristics of the voluntary case are as follows. Number one, the problem is of a one-sided nature. This means that the problem that the applicant is asking to solve is purely related to the interest of the applicant and not related to the rights and interests of others. Number two, there are no dispute with other parties. And the last, it is one party or ex parte. No other person or third party is drawn as an opponent. Next is the regulation of the Supreme Court of the Republic Indonesia number 5 of years 20 and 19 concerning judge line of adjudicating application for marriage dispensation in Article number 6. Its sound is the party entitled to apply for a marriage dispensation is a parent. Number 2, in the event that the parent are divorced, the application for dispensation for marriage is still filled by both parent or one of the parent who has custody of the child based on a court decision. Number 3, in the event that one of the parent has died or it is whereabout are not known, the application for dispensation for marriage is submitted by one of the parent. In the event that one of the parent has died or his authority has been revoked or his whereabouts are not known, the application for dispensation for marriage shall be submitted by the child's guardian. And the last, if the parent or guardian is unable to attend, it is submitted by a proxy based on a power of attorney from the parent or guardian in accordance with the law and regulation. Okay, next your.
Okay. Okay. Thank you for good explanation, Fauzi. So we were in the conclusion part. Okay. Article 7, paragraph 2 of a law number 1 of 1974 concerning dispensation for marriage with the principle of child protection is not yet appropriate. This principle include the principle of the best interest of the child. Then the principle of the right to survival and development and the principle of respect for the opinion of the children. The government's goals to include the marriage dispensation article in the marriage law is to try to not to complicate the affairs of individuals in carrying out marriage. The dispensation article formulated by the government does not show clear parameters, such as under what the circumcase the dispensation can be carried out. The concept of the purpose of enactment of the marriage dispensation is to anticipate emergencies and legalize a relationship so that the things do not happen that cause harm in the relationship. Okay, that's all from us. Thank you very much. Okay, Fauzi, I think you can stop the record. Okay. Thank you. Assalamualaikum warahmatullahi wabarakatuh.